Geoffrey Cox.
Thank you, Madam Deputy Speaker. Madam Deputy Speaker, I've listened with awestruck and impressed to the contributions made to the House today. I was not in the House until 2005, but it is humbling to listen to the sincerity, passion and candour of those who have lived through the experience of having to vote in this House on so weighty and so solemn a matter as sending our country to war. I have not had that responsibility, and it's some trepidation and I hope a degree of humility that I want to offer my own remarks on the motion on the inquiry that faces the House today. And I intend to confine my remarks, Madam Deputy Speaker, to the question of the structure, nature, procedure and terms of reference of the inquiry, and not to venture into the aspects, the substantive aspects of the question relating to the merits of the war on Iraq. But inevitably, Madam Deputy Speaker, the two are connected. And nobody can deny that the events and circumstances relating to the Iraq war were of the greatest magnitude in the history of our nation. Far greater, I would submit, than the events and circumstances of the Falklands War. And one of the reasons that I would suggest that it is of greater magnitude is that it presents as a much greater and more complex series of questions and problems for the House and for history. It presents in that way because it raises much more fundamental questions. It includes a question of constitutional breakdown, as many members of the House have already said. How we came to the war includes the role of the Attorney General, includes an analysis of how the Attorney General interacts with the government of the day, includes questions of law and complex questions of law as to whether the status of the war and what was known to those who were advising the government at that time as to the status of the war in international law. It raises questions of this House and its own prerogatives and the accountability of the government to this House and how it prevents itself being, some would say, deceived by evidence that has been exaggerated or distorted when it cannot see the underlying documents. It presents a question of constitutional breakdown, and it is something that certainly the Franks inquiry never had to contend with, because that war, Madam Deputy Speaker, presented itself in a fairly simple light. There was a question of a defect of intelligence, perhaps a defect, some might say, of the way in which the government conducted policy running up to the Falklands War and the invasion by the Argentine. But what was never questioned, at least not by an overwhelming majority of this nation, was the justification for going to war in the Falklands Islands in the first place. And there was never a question, Madam Deputy Speaker, never a question over the constitutional processes by which that war had been undertaken. Indeed, I recall as a young man listening to that wonderful debate in which Michael Foot gave a great speech, I thought, in 1982, in which he pledged his support and the support of the opposition to the vindication of that little island and its population against the bullying of a larger nation, taking into its own hands international law and making a mockery of it by invasion. So the war that we are dealing with in this inquiry raises much more fundamental questions and will have, I submit, a much stronger effect upon history than the war we fought in 1982. And it is precisely, Madam Deputy Speaker, because of the multiplicity of its aspects that the methods which have been chosen by the government to set up this inquiry are so fundamentally lacking. And let me explain why I say that. Because, Madam Deputy Speaker, there are no terms of reference. The terms of reference that we have seen and which one can espy in the Prime Minister's statement are non-existent. And those terms of reference have not been debated by this House. They have not had the to and fro, the forensic testing and struggle that would exist across the floor of this House in ascertaining and defining precisely the instructions to the inquiry that they must follow. And the reason why that is wrong, and the reason why that does not do justice to the complexity and gravity of the circumstances of the Iraq War, is that many of us might disagree on what the central questions are that ought to be the focus of the terms of reference for Sir John Chilcot. And we cannot leave it to a bunch of civil servants, however distinguished they may be, to decide what are the fundamental questions that they should address. The honourable gentleman, the member for Medway, has defined the central question as he sees it. He says that the central question is how this House came to be deceived by a series of exaggerations and distortions. But others might see the central question of the inquiry as the military unpreparedness of the government to send our troops into war ill-equipped and in many cases unequipped for the kinds of warfare that they were going subsequently to have to contend with. And it is not only that, of course. Others may see the aftermath of the war as the central question. But it is this House, Madam Deputy Speaker, that ought to decide what are the central questions for the decision of the inquiry. It is this House that should define the terms of reference. And it is only by the democratic process of debate in this House on those terms of reference that ever the public listening to our proceedings can have any confidence that it has been established in a transparent and objective way. And so I say, Madam Deputy Speaker, frankly to the government, that the motion which is in the name of my right honourable friend, the Leader of the Opposition, says in terms that the government should submit proposed terms of reference to the House on a substantive motion for full debate and scrutiny. No other proposition can conceivably do justice to the gravity of the circumstances and the solemnity of the occasion with which we are confronted today. And I would urge members on all sides of the House to take into account the importance, as others have said so eloquently, of taking back to this House the right to say to the executive, this is our prerogative. Now, I want to say a word or two about the procedure. Madam Deputy Speaker, historians are generally not particularly experienced at interrogating live actors. I hope that is a pretty non-controversial statement. I have no doubt that the two historians on this panel are particularly good at the interpretation of historical documents and evidence. But I would be surprised if they had much experience, frankly, in winkling out the truth from a reluctant and sometimes even self-deceived witness. There is one forensic tool. I would say this, wouldn't I? I declare interest. But there is one forensic tool, Madam Deputy Speaker, that can be guaranteed to winkle out the truth from a minister or from anybody else, and that is cross-examination. Cross-examination by a skilled and experienced cross-examiner is an indefeasible tool in the hands of the right person and in the hands of an inquiry. And it is absurd to propose, it is fantasy to propose, that somehow by creating the conditions of secrecy, that there is going to be a cosy fireside chat in which the likes of Alistair Campbell will be induced to confide their secret heart to the listening committee. It is only by the forensic tool, Madam Deputy Speaker, of cross-examination that we can hope to get to the bottom of many of the complex and thorny issues with which this committee will be challenged. And I say to the government, if you're going to have cross-examination, and if you're going to get to the bottom of it, you've got to have an oath. And it is no use suggesting, as the Foreign Secretary appeared to do at one point, that somehow you can have some kind of informal administration of an oath. An oath must have consequences. If the oath is to mean anything, it must have legal consequences. And the legal consequences of telling a lie on oath as prosecution for perjury. And therefore, if we are going to have an oath administered, we must have it administered in circumstances which leave no room for doubt at all. But that if you tell a lie, it will be visited with all the penalties that the law has, namely a prosecution for perjury. And that is why I agree with the honourable gentleman for Thurrock, thank you, Thurrock, that the only way is an oath, the only way is to have cross-examination, the only way is to have it in public, where the compelling interests of national security do not otherwise require. And I say again, the only way is that we should have an inquiry that does justice to the gravity of this war and includes upon it men of experience, weight and wisdom, or women, in the relevant areas of this complicated issue. Thank you.